Medical marijuana growers and caregivers can own guns, but patients can't, FBI says in a little noticed memo. Now, this seems a little hypocritical because what's the difference between caregivers and growers and the people that are patients? Well, let's see what the FBI has to say about it. Being a state-registered medical marijuana caregiver or grower doesn't automatically disqualify a person from owning a firearm, the FBI says. But merely possessing a medical cannabis card as a patient does render a person ineligible. Make that make sense. Amid the growing tension between federal gun policies and the ever-expanding state marijuana legalization movement, a little-noticed FBI memo from 2019 offers a lens into the Byzantine legal interpretation surrounding cannabis and firearms, an issue that's recently been raised in the multiple federal court cases. The government has several different ways it assesses firearm eligibility in the context of cannabis, according to the memo from FBI's Criminal Justice Information Services, which was briefly noted in a report from the New York Times last week. In some cases, that involves affirmatively restricting gun rights based on activities or documentation that doesn't necessarily mean a person is an active marijuana consumer. Now, this is literally straight up discrimination, especially if it's for medical marijuana. If you have PTSD or a chronic illness or a debilitating illness, something like that, they're saying, oh, well, you can use cannabis, but you can't own a firearm. Can't do both. Well, I'm just going to let you know before we go any further, the enemy of my enemy is my friend. The NRA is not going to let this go. They want as many people with guns as possible, so I believe there's Supreme Court cases going around where this will be overturned. This is medical discrimination, which is not allowed in this country. At their core, the federal rules say that being an unlawful user of a controlled substance, including marijuana, means a person cannot buy or possess a gun. Would-be gun purchasers are required to disclose such use as part of a ATF form before making a purchase, and lying on that form is a felony offense, as we just saw with the president's son, Hunter Biden. The statute behind the prohibition has been challenged in a number of federal courts over the past couple years, with more than one judicial body determining that the restriction is unconstitutional. The Department of Justice has steadfastly defended the ban. However, contending that medical marijuana patients and everyday consumers pose unique dangers to society that justify withholding Second Amendment rights. Make that make sense. If you or anybody you know is a cannabis user, you know they're probably not a threat to national security, so they have to withhold their Second Amendment rights. It's unreal. Unique dangers to society. Cannabis users are unique dangers to society. Okay, that makes no sense, especially when we have all the science that comes out and says everything that it's already said. But I digress. But the federal government's interpretation of the policy is apparently more nuanced, as evidenced by the memo from CJIS's National Instant Criminal Background Check System that's gone largely unscrutinized since being published more than 4 years ago. A person's firearm eligibility is partly determined by whether their use of a controlled substance is deemed, quote, current. FBI says that's not limited to the use of drugs on a particular day, or within a matter of days or weeks before, but rather that the unlawful use has occurred recently enough to indicate the individual is actively engaged in such conduct. ATF has determined that the present time is represented by the time frame of within the past 12 months. So if you've used cannabis in the last 12 months, you're not allowed to own a gun. That makes zero sense because cannabis users are the most chill people and least likely to go shoot up a building, despite what Reefer Madness showed you. But making the determination also involves an inference of current use or possession that may be drawn from evidence of recent use or possession, or a pattern of use of possession that reasonably covers the present time. What constitutes such evidence isn't quite so simple, however. For example, if a person admits to using marijuana, or if they are in possession of a medical marijuana user card, that's enough to establish an inference of current use for the federal drug prohibition. The document says even without additional evidence of actual current use, the information may be obtained by an individual admitting they have a medical marijuana user card or by presenting a copy of the medical marijuana user card within the past year. The following scenarios will be used to determine the disqualification period in regard to possession of a medical marijuana card. 1 year from the date of the medical marijuana user's card expiration date, or 2, 1 year from the date of admission of possession of the medical marijuana user card if no expiration date is available, or 1 year from the date the medical marijuana user card is relinquished. This is insane. I thought this country was supposed to be giving you more rights instead of taking them away. But notably, the memo does carve out certain exceptions to its cannabis rules for gun ownership, clarifying that possession of marijuana is not disqualifying if the person is identified as a medical cannabis, quote, caregiver, grower, provider, etc. Now, what if you're both? What do you do then? Oh my God! Use of the marijuana or other controlled substance must be established for the prohibition to exist, FBI says. Similarly, an individual may possess a medical marijuana handler's card as a caregiver, grower, or provider for another party, but would not be disqualified unless use was established. Other rules detailed in the memo apply broadly to any controlled substance but stand out for their administrative specificity. For instance, when a person is convicted of possession or use of an illicit drug, FBI counts that as evidence of present use within the last year. Wow. Regardless of the length of time since the arrest itself. So they give you no benefit of the doubt, no matter what. They assume you're guilty until you prove they're innocent. That's backwards. If a person is arrested but their conviction is deferred, that judgment cannot be used as evidence of current use. Instead, the memo says, that information must be gleaned from the arrest report. When it comes to arrest for drug paraphernalia, that on its own isn't automatically disqualifying for firearm ownership. However, such an arrest in the past year, quote, can also be researched to determine if the incident report shows that individual admitted to the use of possession of a controlled substance at the time of a paraphernalia arrest. So, as the cannabis lawyers always tell you, zip it, don't say a word. Drug tests can also be used as evidence to restrict gun rights under certain circumstances. While the memo says an individual officer's assessment or a drug-sniffing dog detecting a controlled substance cannot be used as the evidentiary basis, an incident report about a, quote, baggie containing a green leafy material from the subject's shirt pocket that tests positive for cannabis can be considered proof of current use. Now, I'm pretty positive, as of this moment, beat cops, and patrolmen, they don't have an on-site cannabis test that can show you within minutes how much THC is in there. I know, I worked at a drug testing lab. It took us a long time to determine what was in there. There's no way that they have the ability to test. Not to mention, green leafy, what about CBD? What about THCA that's legal under the Farm Bill? What about anything that's not intoxicating that's green? Seems like they just hate the color green. It's not clear if any of the rules detailed in the 2019 memo have been updated or revised since their issuance. Marijuana Moment reached out to the FBI for clarification, but a representative was not immediately available. Shocker. In the years since the document was issued, numerous additional states have adopted laws legalizing cannabis for medical or recreational use. Widening the gap separating state and federal marijuana laws has prompted legal challenges to the underlying ban. Last month, for example, the Justice Department told the U.S. Court of Appeals for the Third Circuit that historical precedent, quote, comfortably supports the restriction. Cannabis consumers with guns pose a unique danger to society, the Biden administration claimed, in part because they're, quote, unlikely to store their weapon properly. There is so many assumptives in that. It is literally discrimination from a party that says don't assume things about people and don't discriminate based on lifestyles. That is immensely hypocritical, and it really chaps me. I hate that. In a brief submitted in that case, attorneys for the Justice Department argued the firearm ban for marijuana consumers is further justified based on historical analogs to restrictions on the mentally ill and habitually drunk that were imposed during the time of the Second Amendment's ratification in 1791. So they're justifying this because of a law they put in 1791. Let that sink in. They're referring back to a Second Amendment ratification law from 1791. Wow. Okay. The federal government has repeatedly claimed that those analogs provide clear support for limiting gun rights for cannabis users. But several federal courts have separately deemed the marijuana-related ban unconstitutional, leading DOJ to appeal in several ongoing cases. The Justice Department asserted similar points during oral arguments in a separate but related case before the U.S. Court of Appeals for the 11th Circuit in October. That case focuses on the Second Amendment rights of medical cannabis patients in Florida. Attorneys in both cases have also touched on a U.S. Court of Appeals for the Fifth Circuit ruling from August, Daniels v. United States, that found the ban preventing people who use marijuana from possessing firearms is unconstitutional, even if they consume cannabis for non-medical reasons. Hear, hear. So remember that. Daniels v. United States. DOJ had already advised the 11th Circuit Court that it felt the ruling was, quote, incorrectly decided. And the department's attorney reiterated that it's the government's belief that there are some reasons to be uncertain about the foundations of the appeals court decision. The U.S. District Court for the Western District of Oklahoma also ruled in February that the ban prohibiting people who use marijuana from possessing firearms is unconstitutional, with the judge stating that the federal government's justification for upholding the law is, quote, concerning. I agree. Hear, hear. Okay, LA. Let's go. In U.S. District Court for the Western District of Texas, a judge ruled in April that banning people who use marijuana from possessing firearms is unconstitutional, and it said the same legal principle also applies to the sale and transfer of guns. In August, meanwhile, ATF sent a letter to Arkansas officials saying that the state's recently enacted law permitting medical cannabis patients to obtain concealed carry gun licenses, quote, creates an unacceptable risk and could jeopardize the state's federally approved alternative firearm licensing program. Shortly after Minnesota's governor signed a legalization bill into law in May, the agency issued a reminder emphasizing that people who use cannabis are barred from possessing and purchasing guns and ammunition until federal prohibition ends. There it is. There it is. All it comes out. Until it ends, you got to do what we say and don't. Please do what we tell you. That's what they're saying. Oh my God, it's annoying. In 2020, ATF issued an advisory specifically targeting Michigan that requires gun sellers to conduct federal background checks on all unlicensed gun buyers because it said the state's cannabis laws had enabled, quote, habitual marijuana users and other disqualified individuals to obtain firearms illegally. I think you got a bigger problem just worrying about illegal firearms instead of trying to specify who can buy it legally. Start there. Start with just illegal firearms blanketly. Then we'll get to the legal ones. When that problem's solved, let me know. Meanwhile, attorney for President Joe Biden's son, Hunter, who's been indicted on a charge of buying a gun in 2018 at a time when he's disclosed that he was an active user of crack cocaine, have previously cited the court ruling on the unconstitutionality of the federal ban, arguing that it applies to their client's case as well. Well, isn't that convenient for Hunter Biden? Republican congressional lawmakers have filed 2 bills so far this session that focus on gun and marijuana policy. Representative Brian Mast out of Florida, co-chair of the Congressional Cannabis Caucus, filed legislation in May to protect the Second Amendment rights of people who use marijuana in legal states, allowing them to purchase and possess firearms that they're currently prohibited from having under federal law. There you go, Brian Mast. I don't know much about you, but I like that move from you. Senate Majority Leader Chuck Schumer has committed to attaching that legislation to a bipartisan marijuana banking bill that advanced at a committee last month and is pending floor action. That has been pending floor action for, 20 years. It's almost here. We got to push it. It's almost here. We got to push it, push it, push it. They are literally just stringing you along. They're not going to do it until they want. Doesn't matter. They don't care. They're going to do whatever they want. Meanwhile, Mast is also co-sponsoring a separate bill from Representative Alex Mooney out of West Virginia. This session that would more narrowly allow medical cannabis patients to purchase and possess firearms. One place where the matter is particularly relevant is Jersey City, New Jersey, where Mayor Stephen Fulop, sorry if I pronounced that, is suing over a state policy that allows police officers to use marijuana while off duty. What? That challenge, however, has sparked pushback from 2 police officers who've since sued Jersey over what they say is a politically motivated move in a service of a future gubernatorial campaign. So a Democrat is suing a state policy that allows police officers to use marijuana while off duty. I thought Democrats were progressive, or supposed to be. And so tell me who gave you money for your campaign without telling me who gave you money for your campaign. But when it comes to cannabis, especially for medical cannabis, specifically talking about medical, it's a medical condition. Okay? So you're telling me a cancer patient or glaucoma or whoever is not allowed to use firearms? So you're telling me your 67, 77, 87-year-old grandma who uses cannabis for her glaucoma is a unique threat to society? And she's going to go out there and just start shooting up squirrels because she got stoned? I don't think so. If you look closely and read the tea leaves, you see where the money is being flowed from the DEA and the military state and the police state into these Democrats and or Republicans that oppose cannabis in any form. You saw the Republican Party in Ohio, what they're trying to do from a legally passed voter initiative. The people of Ohio voted overwhelmingly to legalize cannabis in the form that it was written. And the Republicans, and it could be the Democrats too, but in this specific instance, the Republicans go, no, we don't like that. So we're going to change it, take it or leave it. And then half the people are going to go, well, at least we got medical cannabis. And then the other smart people are going to go, this is bullshit. There is no way anybody can change a voter initiative approved ballot. That blows my mind. Now, I have no problem with you expanding it and saying, okay, let's go from 4 plants to 8 plants and et cetera, and expanding on it. But to minimize and take away things that voters have approved is literally unconstitutional and against the law and against democracy. But you know that. That's why you're here. So I'm pretty confident that the enemy of my enemy, the NRA, is going to succeed in this. And all these state rulings, they're already there. So they would have to be overturned in federal court in order to overturn this, and then they'd probably be appealed again. So long story short, have faith, don't freak, and continue to stay blessed. Take it easy.